Real people, real cases. This is Verdict Watch.
Parks, did you want to say anything to the court? This would be your one and only opportunity to speak. So
Just to say, deepest apologies to him. It wasn't my plan to, do anything. It just happened out of the flare. That's not like my everyday decision making. I have 5 kids. I have a 14-year-old daughter that's starting high school. So, I wouldn't want them to grow up and go through this. I really remorseful for, ever even doing that to him. He is my elder, and, that's not how you treat your elders. And I do fully understand that. That's not how you treat anybody.
All right. Thank you, Mr. Parks and the complaining witness. This is case number, I believe it's a recall because I think I already called it, but case number 254544901, the People versus Hollis Parks III. This is the date set for sentencing. And let me just get appearances again, please.
Hollis Parks III.
No. Appearances.
Okay.
Mr. Hill. If Mr. Hill is talking, the courtroom is muted.
Oh, I apologize, Your Honor. Good morning. Alex Hill on behalf of the people. Also present is our complainant in this matter, Mr. Rodney Natho. Respectfully, Your Honor, due to some health conditions, we are asking for his permission for him to stay seated.
I think I remember that, and permission is granted.
Will you loudly state your full name, sir?
Rodney Allison Nathan.
Thank you.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Hollis Parks III. Mr. Parks, sir, please say your first, your middle, and your last names.
Hollis Parks III.
Today is the date set for sentencing. And with respect to the pre-sentence investigation, are there any additions, deletions, or corrections on behalf of the people?
Yes, Your Honor. Thank you. Briefly, on page 4, there indicates the defendant's description of the offense. He said that he went to approach the victim because of a car accident. The people wholly dispute that. The cars did not collide.
I do apologize. Hold on.
I think it's the second paragraph where the defendant.
You're on a different. I don't see that period at all, Mr. Frank. Am I looking? I absolutely don't see that. So hold on. Do I have a wrong? I don't have the wrong. This is Hollis Parks III. I'm sorry.
My computer died. I was reading the report right before we started, but I can't refer to it. So essentially.
No. But hold on, Mr. What I'm saying to you is there is nothing in the defendant's description of the offense. You're saying on my record that you want to correct the defendant's description of the offense, and there's nothing in the defendant's description of offense.
Thank you, Your Honor. I'd like to clarify. One moment, please. So, Your Honor, it's actually the police description of the offense.
Okay, and then let me just say for the record, you can't correct the police description of the offense. The police description of the offense is the police's description of the offense.
The people would not like to correct it. They would like to point out that we believe the defendant did not tell the truth in regards to his description of the event, which is troubling to us because there was no car accident that would have justified this road rage. Furthermore, we do want to indicate that, I did do it looks like the pending charges are accurate on page 1. They're both in warrant status from a 2022 incident. And I did see that there were 2 charges, one in the 22nd.
I apologize again. I feel like we're looking at some different paperwork. I do. Okay, pending charge. You saying he has this one case. You're saying the count disorderly conduct and trespass, and they're pending at 36th District Court.
In warrant status, Your Honor.
Okay, that's not what this says, but so you're correcting it that that should be in warrant status?
My review of the Register of Actions indicates that warrant was issued for the defendant's failure to appear.
Okay, thank you.
Properly entered in the system.
Okay.
And then lastly, Your Honor, where it says prior criminal history, and there's no prior convictions, that is accurate. There was no convictions. However, there were two separate cases where the allegation was domestic violence in 2011 and 2012, where they were dismissed due to the complainant's failure to cooperate. I just want to make the court aware of that.
Okay.
No other additions, deletions, or corrections, Your Honor.
All right, Ms. Stevenson.
Thank you, Your Honor. Mr. Parks and I have had the opportunity to review the pre-sentence investigation report. We do offer the following corrections. The pending charge SP 1403912 actually does have, it is not in warrant status. It does have a court date of September 11th, Your Honor, before Judge Ramsey Heath. In addition, Your Honor, on page 5 in the current residence section, that should actually be the current residence is the address on the face sheet of the pre-sentence investigation report. That address listed as a current residence we believe to have been a previous residence. In addition, Your Honor, on the employment section, we want the court to know that Mr. Parks has just started a second job. He has a job that he's listed, that's already listed there, but he also just took a job at Taco Bell, Your Honor. And I'm going to just say that that was in part because he wants to move forward with resolution of this case.
Well, can you help me with the rate of pay? Because that doesn't make sense to me. The rate of pay for the job that's listed, that doesn't make sense.
Understood, Your Honor. I don't have a correction for that. If I might voir dire my client.
Okay, you may.
Thank you, Mr. Parks.
Yes.
Thank you, sir. How often do you get paid at Valvoline?
Valvoline, I get paid every week.
Okay, and what's your weekly take-home pay?
About 600 or close to 7 if I work a lot of overtime. I've been working 50 hours a week lately.
Thank you, sir. Your Honor, is that sufficient for the court?
It is. Mm-hmm.
Okay. Thank you, Your Honor. I don't have the rate of pay for the, that second job because he did just start that. And other than that, we would have no additions, deletions, or corrections. Mr. Parks does stand ready for sentencing.
All right. On behalf of the people,
Thank you, Your Honor.
for sentencing.
We have reviewed the report, Your Honor, and I do think that the recommendation is light based on the conduct. Normally, the people would always leave it to the court's discretion, ask the report be followed, but I think 12 months is too short based on the severity of the violent conduct in this incident, Your Honor. The victim is 84 years old. He was driving a vehicle in his neighborhood to see family, and Mr. Parks violently assaulted him. He suffered some pretty significant injuries. Your Honor, I do have medical bills. We believe the total amount is going to be around the $1,000, but I believe after talking to Attorney Stevenson, we would ask for a 30-day restitution specific hearing. And as far as the sentencing, Mr. Natho has asked me to read his victim impact statement. It goes as follows. Injuries, laceration of left temple and upper cheek, involuntary tearing in both eyes, 2 eye specialists treating my tearing and cut to my left eyeball, internal bruising, soreness on my right thigh and upper middle back, deep bruising, sore to the touch, persistent headaches, pain in my forehead and left temple area, property damage, eyeglasses. My driving eyeglasses were broken, personal reaction. My family is devastated that this happened to me. I am deeply saddened that this incident took place. It was unnecessary. I am 84 years old, a law-abiding citizen, a husband, a father, a grandfather, and a great-grandfather. I already have issues just from old age, and since this incident, I have accrued new issues that we are unaware of how long or what the long-lasting effects could be. My hands are dilapidated already. I wouldn't be able to defend myself if I wanted to, and I shouldn't have been subjected to someone else's rage. The thought of just driving down the road and being approached with such violence is deeply concerning. Signed by Mr. Rodney Natho, who's here present. Your Honor, I know that the family feels that this sentence, it would be appropriate to apply a jail sentence, and the people don't disagree with that. We know that the court has ultimate discretion, and a lot of people get chances on probation. If Mr. Parks receives probation, we hope he takes advantage of that and improves so this type of situation isn't going to happen in the future. We would ask the judge to consider possibly holding some jail time in abeyance just so he knows how important it is that he complies with the terms of probation. Respectfully, that's all we have.
Okay. And you read that statement on behalf of your victim, so he does not wish to make any further statement?
Correct, Your Honor.
Okay. Ms. Stevenson?
So, Your Honor, we do understand the very serious nature of these charges. The people and counsel, along with consultation with my client, did have an opportunity to review the facts of the case at the time that they presented. And it was, we believed it to be in my client's best interest to avail himself of an offer from the people. And the offer that was accepted was an offer that was from the people. We're grateful for it, but that was the people's offer. I am drawing the court's attention to, just one second, Judge. To the police description of the offense, which is consistent with the investigator's report. And it is noted by the officers that as they approach the scene, there is a fight in progress. The fairness of the fight, whatever, I guess that's really is what brings us here. But there is a fight which the police officers observe, Your Honor. So I'm asking the court to take that into consideration in combination with the fact that my client at 32 years of age has absolutely no prior criminal history. We are taking exception to the people's contention that this is a road rage incident, that it's, it just kind of happens in a vacuum. That's not consistent with the investigator's report. There is a report that indicates that there was some type of an automobile accident, and Mr. Parks has accepted responsibility for the fact that, he did not respond appropriately as he attempted to approach the victim and the now victim in this case. So he's accepting responsibility. There's nothing in his past to indicate that he won't fully comply with the terms and conditions of probation. I think it's a fair recommendation in light of the circumstances. We are going to revisit the issue of restitution. We hope if the court does order a restitution hearing, I want to take a look at everything and just make sure that whatever the victim is presenting is consistent with the actions to which Mr. Parks has accepted responsibility. So again, I think it's a fair recommendation. Mr. Parks has already been proactive in making sure that he has the sufficient income to continue to support himself, continue to support his family, and honor whatever obligation would be forthcoming from this court. So I think that I would ask the court not to exceed the probation department's recommendation, Your Honor.
And would your client like to make a statement on his own behalf?
Your Honor, I don't know that Mr. Parks wanted to speak due to the nature of the incident, and I don't know if he's changed his mind since he's heard from people, but initially so he did not want to address the court.
Okay, do you want me to inquire if he wants to?
Mr. Parks, did you want to say anything to the court? This would be your one and only opportunity to speak, sir.
Just to say, deepest apologies to him. It wasn't my plan to, do anything, just happen out of the flare. That's not like my everyday decision making. I have 5 kids. I have a 14-year-old daughter that's starting high school. So, I wouldn't want them to grow up and go through this. I really remorseful for, ever even doing that to him. He is my elder, and, that's not how you treat your elders. And I do fully understand that. That's not how you treat anybody.
Okay. Court is ready to impose sentence. Well, I'm not really actually. Did you say something about a delayed sentence? Did we address anything about a delayed sentence?
The information I have indicates that would have been a delayed sentence, Your Honor.
And you agree with that, Mr. Hill?
I trust Attorney Stevenson as an officer of the court. My computer's.
Oh, yeah, you said your computer day. Okay, so I'm your elder, and the victim whose name I can't remember, and it's only because, I rely on the names on the screen. I do. So if you tell me his name, I'll write it down. Oh, wait, it's in here. I know his name. Hold on. Mr. Natho is like your super elder. It's like, I'm your elder. Because Mr. Natho is old enough to be my father. Means he's old enough to be your grandfather.
Mm-hmm.
And I could imagine that his children and his grandchildren, I don't know how old his great-grandchildren are, but I could imagine that they would be very, very, very angry. Because I wouldn't be able to imagine my 88-year-old mother getting into a car accident. I'm not saying whether or not there was a car accident, but what I'm saying is I would just in my mind want to think that it was a car accident, but it could have been a cutting off, could have been cutting someone off in traffic, could have been, some other things. I don't know because I wasn't there. And the police description of the offense doesn't say that they witnessed the accident itself. They say that they saw Mr. Parks getting out of his car and that. They could have walked up on a fight. Mr. Natho trying to fight for his own safety because clearly it was not a fair fight. It clearly wouldn't be a fair fight between Mr. Parks and Mr. Natho. And if I learned of anyone fighting my 88-year-old mother, I don't know what I would do. I don't know what I would do. And that's why it causes individuals to act outside of themselves. There is absolutely no excuse, no reason in the world except defense of myself, defense of my own personal safety for Mr. Parks to ever have touched in any aggressive way Mr. Natho. There are times when I simply don't understand sometimes I know that we need to negotiate settlements. I do. And I know that there are decisions made in charging. I know those decisions made in charging. And I don't know what receipts could possibly add up to $1,000 that did not amount to aggravated assault. I don't, but I'm not the police and I'm not the prosecutor. So I get the cases as they come to me. But it disturbs my entire spirit that Mr. Parks would hit that gentleman who is in his 80s. That disturbs my entire spirit. And wonder why there wasn't even an additional charge of elder abuse. Because we used to charge elder abuse, right? Why? Because children and seniors are the most vulnerable people in our population. And they need to be protected, whether they are smart-mouthed, whether they are feisty, whether they are whatever. children haven't quite learned yet. And then seniors, sometimes when we get to a certain age, our mental capacity, our physical capacity, it begins to revert back to that of a child. I'm not suggesting that Mr. Nathan has any, dementia or anything like that. I'm not suggesting that. I'm saying our mannerisms, our thinking, it's almost like we go back to an innocence of, certain things or some habits or defenses that we don't realize we've had up, certain things throughout our life. 80-something years worth of experiences Mr. Parks encountered when he encountered Mr. Nathan. And none of them, not even, and I'm not suggesting this occurred, not even Mr. Nathan, being derogatory towards Mr. Parks. None of those things would justify hitting an individual of the age and physical capacity of Mr. Nathan, because you could have just walked away from the car. And it wasn't that Mr. Nathan went to Mr. Parks' car. So you can't even say Mr. Nathan was at his car and he was trying to hit him in the head with the cane. That might justify him hitting Mr. Nathan. But he was at he got out of his car. And why do people get out of their cars angry when they have accidents? It just boggles my mind. If I hit your car, if I crashed into you, if I was whatever, distracted by the stress of life and I cut you off, or why are you getting out of your car angry? It's an accident. It used to be you get out your car and you just exchange your information. You just exchange your information and then you go on about your business. You file your complaint, the police come or they don't, and you go to the thing, you make a report, you give it to your insurance. All of this here, and you got kids, it's ridiculous. It's ridiculous, and it's unacceptable. And it's unacceptable. It's an unacceptable response to a societal norm. And it is an unacceptable response against an individual who are the protected of society. They are the protected of society. And there's no reason for a 30-something-year-old to hit an 80-something-year-old over something that happened in a car. Cars are replaceable. Hitting the complainant at his age could have been catastrophic. It could have caused injury unimaginable. You can't hit him in the same way you could hit me, because he's vulnerable. It would be the difference between hitting me and then hitting a child. They're vulnerable. And we cannot. And your behavior is unacceptable. But for me trying to balance the fact that I do not wish to see people's lives devastated by bad choices, because this was not a mistake. It was a horrible choice that you made. And it's a horrible presentation or showing of what's on the inside of you. Because what's on the inside of you is what comes out of you in times like this. What's on the inside of you. If some older person, and I'm not suggesting that this was Mr. Nathan, because I wasn't there. If I encountered some older person that was angry, that was, yelling at me, that was this and the other, I would say, you know what, ma'am, sir, have a blessed day. Because what I'm not going to do is let you get me caught up and then have to go to jail. You mean, I would probably tell them, you mean, you whatever. And we can either exchange the information or not. But I would never get out, run up to the car. Why you hit me? Why you run up? Because I'm old. It could be any number of reasons. And, maybe Mr. Nathan's family, again, I don't know the situation, but we had to, at a certain point, take my mother's keys. Mom, you don't respond as quickly as you should. Mom, you think you might be going, this speed, but you're not really going that speed. So, Mr. Parks, you were wrong on so many levels. And I believe you should have been charged more harshly. That's how I believe. I believe that you should have been charged more harshly. However, I am going to go with what you were charged with. I'm going to go with the fact that you don't have a criminal history. I do receive, Mr. Hill's information that you were previously charged. But not convicted. So those don't really play a role in my decision today. And so it is the order of the court that you will serve a probation. And now let me say this. Normally, for those who practice in front of me regularly, you know that with his lack of criminal history, I would probably reduce the 12 months. I'm not going to exceed it right now. I'm not going to exceed it because there was an offer for a delayed sentence. So I will do the 12 months, but I'm going to tell you right now, I'm going to let you know my thinking. I'm going to let you know how I feel.
Mm-hmm.
You don't have space to not do this probation, because I do believe you might have needed to go to jail. I believe that. Any person that would hit a 80-some-year-old man, I don't like that at all, period. I think the case was undercharged, and I think I'm okay. So I'm not going to reduce it, but I won't exceed it because I will give the opportunity for the delayed sentence. The law says that you are eligible to be discharged after 6 months, but I'm going to tell you that's going to be, you would have to have been exemplary for me to discharge you at 6 months, because I just think what you did was horrible. So the court is going to set the probation. The final review is going to be September 4th of 2026, but you will be eligible should you complete the terms and conditions of the probation. You will be eligible to be discharged after 6 months. Which would put us 1, 2, 3, 4, 5, 6 in March. So, but I will set a restitution hearing. So forget the March date. Let's go with the 30-day date on October 7th for the restitution hearing. Okay, so I'll set a restitution hearing for October 7th at 10 o'clock. And then the 6-month review date will be March the 6th. I think. I haven't been keeping track. Do I have any reviews on March 6th?
Just 4 discharges, Your Honor.
Okay. All right, March 6th for that next review, but the focal point date is October 7th, and the conditions are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of this court, and you must make a truthful report to probation on a monthly basis, notifying them immediately of any change of address, phone number, or employment status. You are going to pay the following fines, costs, and fees. The mandatory cost of $210, a $100 attorney's fee. I'm sorry. $500 fine. Restitution is to be determined. $420 in oversight fees at a rate of $35 per month. A $50 pre-sentence investigation and substance abuse evaluation fee. I'm sorry, I forgot to check something. Okay. Total fines, costs, and fees, $1,280. That does not include any restitution. That is the 12-month amount. Court is not ordering random urinalysis at this time, but at the discretion of probation, they may order you for urinalysis if they see a need. You shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card, no opiates without a valid prescription and letter of explanation, no driving without a valid driver's license. You will attend 12 weeks of anger management. You will complete I'm going to accept the recommendation for 5 days of community service, which is equivalent to 40 hours. And you will pay any outstanding tickets that you have with 36th District Court. According to the report, your balance is 0, but you do have the 2 outstanding. No, those cases are not in warrant status. You will participate in a GED program, as it indicates that you have not obtained your high school diploma. You will have absolutely no contact with the complaining witness. You will maintain employment. And if I didn't already say so, you will participate in the Choices program as well. This order will be mailed to you at the Hawthorne Street address, and probation will contact you at the phone number ending in 2303. Is there anything further on behalf of either party?
Not by the people, Your Honor. Thank you.
Nothing on behalf of Mr. Parks. Thank you very much, Your Honor.
All right. And then we have until October the 7th to get in any receipts. Well, really October the 5th, so Ms. Stevenson can look at them, but I think you may already have them if I heard correctly. But the restitution hearing is October 7th. And then if necessary, I will amend the court's order to include restitution. Anything, you all already said, nothing further. All right, then everyone have a great day. Stay safe.
Thank you.
You're welcome.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.